come in an intro and some health and safety. So if we just open that up to you, Milton, thank you.
I te hui whānei, whaia tō mātou tauranga kia marama ai, kia whaia ake kōrero, katoa, tū maia, aroha mai, tātou ia tātou katoa, tūturu whakamaua tīna hui e taiki e.
Thank you, Milton. So, no mai haere mai, welcome everyone and a very warm welcome on a very chilly day. I'm looking at the group today and I'm thinking you're all smart people. You know where to come to get free legal advice and a cup of tea. So that's fantastic. Just a bit of housekeeping first. There's bathrooms around the corner and there's also another ladies' bathroom out there. In the event we all get chucked out through fire or evacuation, we'd meet out in the back in the car park. So it's my very great pleasure to introduce Rachael today, Rachael Wiltshire, who's going to give us all this legal advice. What comes up to us very often is questions that we don't know the answers to, and regardless if it's disability law, elderly parents or anything, triple P&Rs, all those sorts of things will come up in our lives in some time. Discrimination happens on a regular basis as well, and we just don't know where we can go to sort that out, so hopefully we get all the answers today. Rachel's very in high demand, so we're very privileged that you've made some time to come for us today. She's also very involved in Altogether Autism as well, so she has a background in assisting a lot of people in different lives as well. So without further ado, I'd like to hand it over to you.
Thank you. And I should probably take the video microphone from you.
You're welcome.
Thank you. Get that on there. Kia ora. Thank you so much for having me, everyone. Before I get started, I'm just going to hand around a handout that you can all take away with you for this first session this morning about disability discrimination. That just means that if you are taking notes, you can focus on just writing down the things that are not on the handouts. Thank you guys for sharing those around. So yes, as Peter said, my name is Rachael and I work as a community educator for Aotearoa Disability Law. Some of you may have known us under our previous name of Auckland Disability Law, so just to avoid any confusion there, we are the same organisation. We changed our name at the end of November last year just to reflect the fact that we do in fact cover the whole country. It's not only limited to Auckland. So we are a community law centre. So community law centres offer free legal advice, and most of them, there's 24 around the country, most of them are in a specific region of the country. So for example, here in Tauranga you've got Bay-wide community law, and they can generally provide you with free legal information and advice. We are a little bit different. We are a specialist community law centre, so we specifically focus on helping deaf and disabled people if you have a legal issue that's related to your disability. So no matter where in the country you are, if you have a legal problem and you think it's related to your disability, you can give us a call, and if it's not something we can help with, we can hopefully point you in the right direction towards someone who can help. So our one-on-one work with clients is a big part of what we do, but another thing that we do is legal education sessions like this, just to help people know what their rights are and how the law works, and that's what my role is. And then we also get involved in law reform work. So if there's issues that are going to affect the disabled community, and perhaps there's an act going through, a bill going through Parliament, or there's the government's doing some sort of investigation or inquiry, we will get involved in that where it's relevant. So As Peter said, the first thing we're going to talk about today is disability discrimination. Then we'll have a break for morning tea, and so you can spend some more time looking at the stalls out there. And then we'll come back and we'll talk about supported decision making and the Protection of Personal and Property Rights Act. So just need to say up front, we should have time for questions at the end of both sessions, so feel free to send your questions my way at the end of the session, but I should say that I'm not a lawyer myself, so I'm very happy to answer general questions, but if it's a specific situation about your individual situation, that's probably not something I can answer, and in those situations, that's when it's best to get in touch with our office to see if one of our lawyers can help, and our contact details are on the back of your page, on your handouts. So, to start talking about disability discrimination, let's start by talking about human rights. So, I'm sure we all know what human rights are. They are the basic rights and freedoms that we all get as people. And on this slide, there's a couple of key things about what human rights are. So they're inherent. We're all born with our human rights. We don't have to do anything to get human rights. They're inalienable, so you can't sell your human rights or give them away. And they are universal, so everyone gets human rights. And alongside rights come responsibilities, so we all, as well as having human rights, we have a responsibility to protect the rights and freedoms of other people. Now, one of the main pieces of law that protects human rights in Aotearoa, New Zealand, is the Bill of Rights Act 1990. So what this act does is it takes international statements, international declarations about human rights, and it puts them into our laws in New Zealand, and it also tells our government that they have to make sure those rights are upheld. And so the Bill of Rights Act can serve as a little bit of a check on government action towards the people of New Zealand. So a court can declare that a law is inconsistent with the Bill of Rights Act. However, in New Zealand we have this concept called parliamentary supremacy, which basically means that Parliament can pass any law it wants to. So Parliament can still pass a law that is inconsistent with the Bill of Rights Act if it wants to. The courts can't say, no, you can't do that. But obviously that helps then voters at the next election judge who they want to give their votes to. So the Bill of Rights Act lists a number of different rights, but the one that we're going to focus on today is the right to be free from discrimination, and that is in Section 19 of the Bill of Rights Act. But all the Bill of Rights Act really does is it sets out the broad legal basis for our rights. It says these are what our rights are. But in terms of how those rights actually get enforced on a day-to-day basis, that usually comes down to various different pieces of law. So for example, you've got a right to education. How that actually happens comes into the Education and Training Act. In the case of the right to be free from discrimination, the law that actually sets out what discrimination is in New Zealand, what unlawful discrimination is, and how you can get things fixed if you have been unlawfully discriminated against, is the Human Rights Act 1993. And so that's the main law that we're going to be focusing on in this first session this morning. So basically, unlawful discrimination, as it says on the tin, is discrimination that is not allowed by the law. And it's really important to know when discrimination is unlawful, because that means you know when you can complain and hopefully get something fixed. So the Human Rights Act sets out a little bit of a formula for when discrimination is unlawful. So it says that discrimination is unlawful when you are treated differently in a way that leaves you worse off. When the reason why you were treated differently is one of the prohibited grounds listed in the Human Rights Act, and when the discrimination happens in one of the areas of life covered by the Human Rights Act. So you've got to have those three things happening for discrimination to be unlawful. If If you've got those three things in place, the discrimination is probably unlawful, but you do also just need to check that an exception doesn't apply, because sometimes there are situations where there's a good reason why discrimination needs to happen, and the exceptions in the law cover those situations, but we will talk about that in more detail later. So basically what we're going to do now is go through each of these parts of the formula one by one. So the first part is being treated differently in a way that leaves you worse off. Now, being left worse off could look like a lot of things. It could just be emotional harm. It could just be that the way you've been treated has hurt your feelings. Or it could be something more material, like meaning you lose out on money or have to pay more money, or meaning you miss out on an opportunity. So, for example, if you apply to study at university and they say, no, you're blind, we're not going to consider your application, that would be being treated differently in a way that leaves you worse off, because you would be missing out on the opportunity to study at the university. Now, sometimes discrimination is intentional, meaning that the person meant to treat you differently, but sometimes it's unintentional, meaning that the person treated you differently by accident, or maybe they just didn't understand what the consequences of their actions might be. It's important to note that the Human Rights Act doesn't make a difference between whether the discrimination was intentional or unintentional. So it doesn't matter whether the person intended to treat you differently or not. The key thing is that they did treat you differently. If they've treated you differently, it's still discrimination, even if they didn't mean to do it. And this is really important, partly because it stops people from discriminating intentionally and then turning around and saying, sorry, I didn't know that would be the effect, so I can't get in trouble for that. A really good example of this type of accidental or inadvertent discrimination was, if we cast our minds back almost 5 years now, the New Zealand COVID Tracer app, which you might have blanked out that section of history from your mind. But when that app was first released, it didn't give an audio or a vibration cue when people successfully scanned the QR code. So this meant the app was really inaccessible for blind people and people with low vision, and that had ongoing consequences for their lives, because that meant they had more difficulty going to places where you had to scan the QR code, like shops. Now, obviously, in this instance, the government didn't mean to discriminate against blind and low vision people when they were creating the app. They just didn't think through how the app would be accessible for all different kinds of users. And what happened in this case was that people complained that the app was inaccessible, and it was updated to both vibrate and give an audio cue when you successfully scanned the QR code. And this is a really good example, because it shows that it is actually important to complain about things that are inaccessible or discriminatory, because in many cases the person or organisation that is discriminating might genuinely not be aware that they're discriminating, and once they know about the problem, they will want to fix it. So the second part of the discrimination formula is that the reason why you were treated differently has to be one of the prohibited grounds that are listed in the Human Rights Act. So the prohibited grounds listed in the Human Rights Act are age, colour, race, employment status, so that's things like whether you have a job, whether you don't have a job, whether you work part-time, full-time, that sort of thing. Your ethnic or national origin, your family status, so that's often looking at things like whether you have children you look after or not. Your marital status, so that's whether you're single, whether you're married, whether you're in a civil union. Your ethical beliefs, religious opinions and, religious beliefs and political opinions. Your sex, your sexual orientation, and whether you have a disability. So these are all prohibited grounds for discrimination, but today we're just going to focus on that last one, the prohibited ground of disability. So the Human Rights Act actually has a definition of disability. This is in section 21(1)(h) of the Human Rights Act, if you ever need to tell someone what where that is. And this definition is the main definition of disability in New Zealand law. So often in other laws, if it refers to disability and people are uncertain what that means, this is the definition they will refer back to. And you can see the text on this slide, which we will go through in a minute because I know it's a little small, is the text as it is written in the Act. So the key thing is that this is a really broad definition. It sets out broad categories that should theoretically cover anything that could possibly be disabling. It's not a list of specific conditions or impairments that say this is a disability and this is not. So basically, the Human Rights Act says that a disability means a physical disability or impairment. So that could be things like whether mobility issues, whether you're a wheelchair user, a physical illness, so that's often, things like multiple sclerosis, for example, would probably come into that category. A psychiatric illness, so that's where our mental health conditions come in. An intellectual or psychological disability or impairment, so again, that's where things like potentially Down syndrome or autism would fit in there. And then just in case those first 4 categories weren't broad enough to capture every possible disability, they also have any other loss or abnormality of psychological, physiological or anatomical structure or function. So hopefully if something is not quite captured in those first 4 categories, it should at least fall within the anything else category that's there at the end. And then there's a couple of other things. Number 6 is reliance on a disability assist dog, a wheelchair or other remedial means. So that's basically referring to relying on any assistive technology to help you live your life more easily. Again, that other remedial means is quite important at the end there. This law was written in 1993, so it's relatively old for a law, and obviously back in 1993 we didn't have nearly as much technology as we do nowadays to support disabled people to live good lives, and the fact that back in 1993 they put other remedial means in there means we don't have to update the law every time a new form of assistive technology is developed. It's automatically covered by the law. And then the final category of disability in there is the presence in the body of organisms capable of causing illness. This was actually added a little bit later after the Human Rights Act was first passed, and it was put in there to cover people who were HIV positive because they were experiencing discrimination and people weren't sure if they were explicitly covered by this definition of disability, so they put that in there just to make sure they got captured as well. The other important thing to note is that this definition doesn't differentiate between temporary and permanent disabilities. So discriminating against someone who has a physical impairment while they recover from a broken leg is no different under the law from discriminating against someone who is a lifelong wheelchair user. So the third part of the disability discrimination formula is that the discrimination has to happen in one of the areas of life that are covered by the Human Rights Act. So the areas of life covered by the Human Rights Act are the government and the public sector. So that's things like interactions with your city council, with the police, when you're going to vote, interactions with WINS, all that sort of stuff. Employment. Education, this is all stages of the education system, so all the way from early childhood education through to tertiary education. Access to public places, vehicles and facilities, so that would be covering things like going to visit the museum or the swimming pool or using public transport. Provision of goods and services, so this is basically anything that you pay to access, so going to the supermarket or going to the dentist or the hairdresser. Land, housing and accommodation, so this is renting and buying a house. Industrial and professional associations, qualifying bodies and vocational training bodies, so that's things like being able to join your union or being able to be part of a body that does the qualifications for a specific profession. And finally being a partner in a firm or organisation. So the one key area of life that the Human Rights Act does not cover is our private relationships, so our relationships with friends and family. So for example, if you have a friend who throws a party and they say, no, you can't come because you're disabled, doesn't make them a very nice friend, but you can't say that they're unlawfully discriminating against you. And that's probably a good thing. You probably don't want the government interfering in your personal private relationships. So to have unlawful discrimination happening, as I said at the beginning, we have to have the top 3 things on that slide happening. So we have to be treated differently in a way that leaves us worse off. The reason why we were treated differently has to be one of the prohibited grounds listed in the Human Rights Act, and then the discrimination has to happen in one of the areas of life covered by the Human Rights Act. If we've got those 3 things happening, we probably have unlawful discrimination happening, but we do first have to check that an exception doesn't apply. So the Human Rights Act has exceptions written into it that take account of the fact that sometimes there are good reasons why discrimination needs to occur. So as one example, political opinion is a prohibited ground of discrimination in the Human Rights Act. Employment is an area of life in the Human Rights Act, but obviously it makes sense that a political party should be able to choose to only employ people that share their political beliefs. So in situations like that, where there's a really good reason why the discrimination needs to occur, the Human Rights Act tries to take account of that through the exceptions. It's important to know that the exceptions are written into the Human Rights Act, so someone can't just discriminate against you and then make up an exception to get out of getting in trouble. If an exception applies, it will be one of the ones written into the Act. The exceptions are probably one of the most complicated parts of the Act because, as you'll see from the language when we talk about some examples of exceptions related to disability, it's often a little bit of a balancing act. So if you feel like you've been discriminated against but that an exception might apply, or the person who discriminated against you is saying, no, this exception applies, that's when it's really a good idea to get in touch with someone who understands human rights law, like a lawyer or the Human Rights Commission, which we'll talk a bit more about in a minute, because they can advise on whether an exception actually applies or whether it doesn't, and therefore you have been unlawfully discriminated against. So the exceptions are written into the Act for each specific area of life. So there are exceptions related to employment, there are exceptions related to education, there are exceptions related to the provision of goods and services, and so on. So it would be impossible for us to right now go through all of the exceptions in the Human Rights Act, but there are 2 really common types of exception in relation to disability that I just wanted to highlight. So the specific wording varies a bit between each area of life, but most areas of life have these 2 exceptions related to disability. So for most areas of life, there is a statement and exception that it's okay to treat disabled people differently if there's a risk of harm either to the disabled person or to other people, and it's not reasonable to take that risk, provided that reasonable steps can be taken to reduce the risk to the same level as it would be for any other person. So that's really important. It's not just that health and safety is an exception. We can just say, oh, it's not safe, so we can unlawfully discriminate against you and that's fine. You have to take reasonable steps to try and reduce the risk, or the health and safety risk, to the same level as it would be for a non-disabled person first, and only if the health and safety risk still exists at that point can you say that this exception applies. And this is what I mean about kind of the balancing act. Obviously, what counts as reasonable steps is going to really vary depending on the situation. So for example, if it's a really small business, the decision might be that it's not reasonable to expect them to pay for the cost of installing a ramp, whereas if it was a larger business that has makes more profit, it might be more reasonable to expect them to make that accommodation. But judging what is reasonable is what is really tricky about the exceptions, and so that's where you really want to talk to a specialist in human rights law who can advise on whether something has been reasonable or not. And then the second exception that is often there for disability is there's often an exception that says it's okay to not provide a disabled person with special facilities or special services if it's not reasonable to provide those special services or facilities. So again, we get this word reasonable, which is not an especially precise word and is a judgment based on the situation. So some factors that might be taken into account if you're determining whether it's reasonable to provide a special service or facility is things like how much it's going to cost, whether the service is readily available, if it's building modifications, whether it's actually possible to make those building modifications, that sort of thing. Basically, this is why the exceptions are one of the most complicated parts of the Human Rights Act. And this is why if you feel you've been discriminated against and the person or organisation that discriminated against you is using one of these exceptions to say, no, it's not unlawful discrimination, I would really encourage you at that stage to get in touch with a lawyer or with the Human Rights Commission because they can help judge whether the person that discriminated has acted reasonably or not. Which brings us to the last part of this presentation, which is what should you do if you have been unlawfully discriminated against? So firstly, it's really important to keep a record of what happened. So you can write some notes about the situation, or if you've got any emails or messages, that sort of thing that relate to the situation, save those somewhere safe. You want to try to make this record as detailed as possible. So if you can, include the dates when things happened. If you know the names of people involved, try to record those as well, that sort of thing. A detailed record is going to be really helpful if you do end up needing to make a complaint about unlawful discrimination. The more evidence you have to back up what you're saying, the better. Obviously, it doesn't feel nice to be discriminated against, so it can be a good idea to talk to a support person to help you navigate the situation. They might do things like help you talk about how you're feeling about it, help you create that record, and help you make a complaint. Then, if you feel up for it, it's a good idea to try to talk directly to the person or organisation that discriminated against you. It's always a good idea to try and solve problems directly with the organisation if you can. So, for example, sometimes people aren't aware that what they're doing is unlawfully discriminating against you, and they will want to fix what has happened if you bring the issue to their attention. But sometimes you can't resolve the situation by talking directly with the person, and sometimes you might not feel comfortable talking directly to the person. In either of those sessions, the best place to go is Te Kāhui Tika Tangata or the Human Rights Commission. So they have been set up, they're set up by the Human Rights Act to receive and investigate complaints about unlawful discrimination. And so they can investigate a complaint and help you to solve it. If you can't get it solved directly with the Human Rights Commission, they also can then escalate it to the Human Rights Review Tribunal, who can make a binding legal decision. So there's lots of ways you can get in touch with the Human Rights Commission. They've got an online complaint form on their website. You can phone them, you can text them, you can email them. All these details are on your handout, so don't you don't need to worry about writing them down. And it is free to contact the Human Rights Commission. Generally, you will need to make the complaint to the Human Rights Commission within 1 year of the discrimination happening, but they are sometimes able to extend that time frame. So if it has been more than a year and you're sitting there thinking, oh, actually I think this was unlawful discrimination and I'd like to do something about it, it is still worth getting in touch with them to see if it's possible to complain. You can also, if you want to, speak to a lawyer to help you understand your options for resolving the situation. You don't need to have a lawyer to go to the Human Rights Commission. You can talk to them directly if you want to, but if you'd like to speak to a lawyer, that's definitely an option that's available to you. And this is absolutely the sort of issue that we help people with at Aotearoa Disability Law all the time. So again, just to reiterate, we provide free legal advice, so it doesn't cost to come to us, and we do support deaf and disabled people living all over the country. So even though most of our lawyers are based in Auckland, you don't have to be based in Auckland to access our services. Again, our contact details are on your handouts and also on that slide. Your local community law centre, so Baywide Community Law, may also be able to help. That can be a good option if you want to be able to go in and see someone in person. And finally, the final thing that is on your handout is the website for the Law Society. The Law Society is the registration body for all lawyers in New Zealand, and they have a register with the contact details of every lawyer, so you can search there to find a lawyer that you want to contact. Just be aware though that a lawyer that you find on the Law Society's website is likely not free. They're likely going to be someone who charges, but they should tell you what the costs will be before you engage their services. So just as a summary, today we talked about what unlawful discrimination is under the Human Rights Act. So remember, we've got that formula. You have to be treated differently in a way that leaves you worse off. The reason why you were treated differently has to be one of the reasons listed in the Human Rights Act, and the discrimination has to happen in one of the areas of life covered by the Human Rights Act. If we've got those three things happening, we've probably got unlawful discrimination, but we do also just have to check that an exception doesn't apply. And if you feel like you've been unlawfully discriminated against and you need some help solving that situation, the best place to go is Te Kāhui Tika Tangata, the Human Rights Commission. You can also contact a lawyer if you want to. So that's the end of what I have to say about disability discrimination, but I am very happy to answer any questions that anyone has. Yes?
I have a question about keeping a detailed record. Because obviously for a lot of people with a disability that might be very difficult to do. And if a third party keeps the record, how is that seen? Is that then a problem, or?
I don't think it would be a problem. Just in the same way that if you were acting in the role of support person, one of the things a support person might do is help with keeping the record. I think the key thing is that basically the more evidence you have, the easier it is for the human rights. If you do end up complaining to the Human Rights Commission, the easier it is for them to investigate. And so it shouldn't really matter who has the record, as long as you're able to get that information to the Human Rights Commission when they need it, if they are investigating the complaint. Yes?
What's the difference between human rights and the Bill of Rights?
So the Bill of Rights, I guess arguably human rights are things that we all just have as people. They shouldn't need to come from any specific law or anything. They're just rights that we should all get as people. And they're written into lots of international declarations, most famously the United Nations Human Rights Declaration. I can't remember its correct name off the top of my head. But the UN does a lot of work on making declarations about what human rights are, for example. What the Bill of Rights does is it's a specific New Zealand law that actually writes those rights down for New Zealand. So human rights exist anyway. They apply to everyone, we get them as people, but sometimes it's helpful to have them written into law to make sure that those actually get upheld, and so that's what the Bill of Rights Act does. It takes those human rights, it writes them down, it says, as a person in New Zealand, these are the rights you should have, and then it also says, you know, if the government's doing something that affects these rights, firstly, if the government is passing new laws, they have to do, I think it's the Minister of Justice, has to check and see whether that law might impact any of those human rights listed in the Human Rights Act, and if it does, they have to tell Parliament about it. Again, Parliament can still pass the law if they want to, but it sort of makes that a bit more transparent for everyone. And also, if people think that a law does breach the Bill of Rights, they can take that to court and ask the court to make a declaration on that. The example of that you might be most familiar with recently is when the Supreme Court said that having a voting age of 18 was inconsistent with the Bill of Rights Act, because the Bill of Rights Act protects against discrimination on the basis of age. But obviously, so the Bill of Rights Act kind of takes those human rights, puts them into law and says these are some things you can do about it if those human rights are breached. But obviously it's not necessarily the most effective way of doing things about it, because Parliament can still pass any laws that they want to. So for example, the court said a voting age of 18 is inconsistent with the Bill of Rights Act, and Parliament said that's okay, we're not worried about that, we're not going to change the voting age. Yes?
How does it relate to migrant populations within New Zealand and new migrants and so on? There's a lot of discrepancy, of course, around people being discriminated because of their disability to actually get a visa to come to New Zealand and so on. So
yeah, so that is obviously arguably a human rights issue. I think I'm not sure if anyone ever has done. I think you could probably bring a case that argued that discriminating against, the ability to get a visa or the ability to get citizenship on the basis of someone having a disability would be unlawful discrimination, but basically the way that would need to be tested would be that someone would have to take a case, you'd have to start at the Human Rights Commission, you'd have to go to the Human Rights Review Tribunal, and from that point it can enter into the court system and get a court to investigate it. The court could then say, no, this is unlawful discrimination, but again, Parliament can still say, obviously it's Parliament that makes the laws about who is eligible for visa status. Parliament can still say, we're not going to change the law. So, yeah, at the moment, as far as I'm aware, there have been no cases that have taken that to the courts. The courts have not made any declarations on whether discriminating, deciding whether someone can get a visa on the basis of having a disability is unlawful discrimination. I think there's probably a pretty good case that it is unlawful discrimination, that it does breach people's human rights. But again, the argument from the government would probably be that we're concerned about the cost that people will have on the New Zealand taxpayer, and maybe it's reasonable to discriminate in this way. So I think that's the sort of situation. Often, the way that our legal system works is the Parliament writes the laws, and then the courts do the work of interpreting those laws in relation to specific sets of facts. So probably until a case like that gets into the court system, we won't know exactly how the courts would come out. But yeah, as I say, I think there's probably a strong case, but but that doesn't necessarily mean that there's a lot we can do about it. And so that's probably, again, one of those issues where bringing a court case could be part of a political campaign, a campaign for change, but it's probably partly also campaigning to politicians to change those discriminatory laws. Yes?
The housing area is probably a big grey one because you see lots of ads for people saying they want someone that works full time, they want a male or a female.
Yeah, so I think that would be in relation to like advertising for flatmates and things, wouldn't it? So I think specifically with housing, if you are I can't remember the exact wording, but I think there is an exception that if you're advertising for someone to live in your house with you, then you do have there are exceptions that let you specify, for example, the gender of the person that you want it to be. Likewise, you know, if you're advertising for someone to do personal care, for example, even though sex is a prohibited ground of discrimination in the Human Rights Act, if it's really intimate care, for example, you're obviously allowed to say, I would like this to be a person that is the same gender as me. So that probably, some of that probably falls under the exceptions, but that would be in the situation of if you're advertising for someone to be a flatmate, for example. If it is a landlord that's advertising a house for rent and they're not going to be living in the house with the person, then that would be unlawful discrimination to say, I only want tenants who work full-time. Probably. Again, I think the thing about the law is that we'd really like it to be nice and black and white, but there's obviously a lot of grey area. And so that would then, this is when it then comes to sort of looking at other laws. So for example, if you're wondering what unlawful discrimination looks like in terms of renting to people, you've got the Human Rights Act, but then you also have to look at the Residential Tenancies Act, which has all those laws, which has a lot more specific detail about what exactly is and is not okay, and also tends to be one that changes quite frequently with different governments having different priorities about what should be allowed in housing. So yeah, some of that is probably okay because of some exceptions, some of it is probably not, and it is going to depend really on the specific situation. Yeah, so sorry I can't give a more specific answer than that. Yes?
Another one I've come up on a lot, and that is job applications where the requirement of a driver license is specified, which for many of us disabilities can be discriminatory.
Yeah.
What is the position there?
So I guess, again, the Human Rights Act doesn't say anything specifically about driver's licenses. The thing with employment and applications for employment is that obviously employers can't discriminate in hiring on the basis of disability, and the Human Rights Act does also say that they're not allowed to ask questions in the application process that could indicate that they intend to discriminate on the basis of disability. So for example, it would be unlawful for an employer to ask a question, do you have a disability? But they are allowed to ask specific questions about your ability to do the job. So that's probably where a driver's license would fall into. It would again depend on whether having a driver's license was a really specific requirement of doing the job or not. So if it's a job where driving is a key part of the job requirements, then that's probably something that it's okay to ask for. If that's something that they just want you to have a driver's license because they think that's the most reliable form of transport, that's probably something where they shouldn't be asking, do you have a driver's license? They should be asking, do you have a reliable form of transport to get to work? So I think often a good way of approaching that and approaching any questions about disability in employment applications is to go back and ask, could you tell me a bit more why this job requires a driver's license? And then if they say, oh, we just like everyone to have a driver's license just in case, say, well, I don't have a driver's license, but I get around really reliably on public transport, or I have my total mobility card, or whatever, is it okay if I apply anyway? So yeah, that's probably how that one would go. They should really only be asking that if it specifically relates to the job duties. And again, they have a duty to accommodate people as much as reasonable if there's something that they can't do because they have a disability. So even if it's a job where maybe it's like, well, you might need to drive occasionally, so we want you to have a driver's license, that's probably not reasonable. If it's driving every day, probably reasonable to require you to have a driver's license. If it's once a month, you might need to drive to the post office for us, that's probably not reasonable, and they'd probably be expected to find another solution. Yeah, hopefully that answers that question. A lot of it is, it depends on the situation. Cool.
Questions? I just wanted to, I think it's great to have legislation, but it's also about education and the subconscious discrimination, the silent discrimination that we all face in different times come across. How do you think we've progressed over the last few years about educating people, and have we seen progress on that to get people to a point where we're not separating out certain groups of people and saying we're not, especially in employment and housing that's been brought up, those social issues?
Yeah, I mean, I think that is a very good point. That I often say that the law is like kind of a backstop, but it's not the only thing we need. What we really need to do to stop people discriminating against is to change culture so that we all see discrimination as not okay. But obviously, as part of changing that culture, it's helpful to have the law to fall back on when unlawful discrimination does happen. I think there are still obviously some really big issues in terms of people getting jobs. Obviously, we know that, for example, access to employment is a really big barrier for, with my Altogether Autism hat on, autistic people have really big barriers to employment. A lot of disabled people, again, access to housing, also education. So I think there's lots of areas where there's room for improvement, and often part of that is need for increased funding for these services. But I think that people are increasingly aware of these things, so we do see, you know, increasing numbers of employment programs for people with specific disabilities, or employers talking more about being disability-friendly employers, for example. So we are sort of seeing that culture change happening, but there's still also a long way to go. Another good example of that is like the Education and Training Act 2020 says that students with disabilities have the same right to enrol in and attend state schools as any other student, and they have the right to be at school for all the hours that the school is open. So you'd think that's a really good step forward in terms of not discriminating against children at school, but obviously I'm sure you all know discrimination still happens at school all the time. Schools don't feel like they can accommodate disabled students, and that's a really good example of the government changed that law, but they didn't put any additional funding into actually giving the schools the support they need to include disabled children. So yeah, I think we're making slow progress, but there's still a long way to go. And some of where the change needs to happen is maybe not so much the law as it is the culture, and also being willing to fund the services that people need. Cool. Well, if no one has any more questions, then that's perfect because it gives us about 20-25 minutes for morning tea and having a look around the stalls. Obviously, if any other questions do pop into your mind, we'll be doing another presentation after this, so when we have the question time for that one, you can always bring up a discrimination question again.
Thank you very much, everyone. So Kelly's provided our morning tea for us. Thank you, Kelly. Same here. It's always very good. So I think, thank you, Rachel. There's some thought-provoking ideas come through. I've got a lot of questions about even my own subconscious as well, of when I'm employing staff, what I'm doing, and who am I looking for specific people, and how much accommodating I do around that as well. I hope I'm good. I hope I'm meeting all those requirements, but sometimes there's always room for improvement. And we look at that, who's the right people to support the right person. So please mix and mingle, come and ask some questions, have some morning tea, as said, and then we'll get together in about 20 minutes for the PPPR discussion, which is very thought-provoking and quite complex in some areas, but and then you also don't understand how it all ends as well for some people. Thank you very much.
That's okay. Thank you.
In terms of...
So basically for this session, we're going to talk about two main things. I'll just wait for everyone to finish coming back in. That's all good. Cool. So we're going to talk about two main things in this second session. First, we're going to talk about what supported decision making is, what the legal frameworks are that empower people to use supported decision making, and how supported decision making can actually work in practice. And then we will look at what options the law gives us when more than supported decision making is needed, and that's when we're looking at the Protection of Personal and Property Rights Act and enduring powers of attorney. So again, same little caveat as before, we'll have time for questions at the end, and I am very happy to answer any general questions you have, but just a reminder that if it's something that's really specific to your individual situation, that may not be something that I can answer. So let's start by talking about supported decision making. So supported decision, basically everyone makes decisions about their lives, and sometimes we all need support to make decisions. So if you think about a big decision that you've made in your life, you might have researched some of the different options, you might have talked through those options with a friend, for example. Sometimes disabled people need extra support to make a decision, and so that's what we call supported decision making. So supported decision making assists disabled people to have choice and control over their own lives, whilst also ensuring that they have the support they need to exercise that choice and control. And supported decision making is a human right. So Article 12 of the United Nations Convention on the Rights of Persons with Disabilities, which New Zealand has signed, says that everyone has the right to use supported decision making if they want to. And the New Zealand Disability Strategy, the current version of which runs from 2016 to 2026, also says that people in New Zealand have the right to use supported decision making. They're currently rewriting the disability strategy, and I imagine that will continue into the new version of this disability strategy. And then we also do have the Protection of Personal and Property Rights Act, and that is the law that sets out the legal rules for situations when someone else is allowed to make decisions on a person's behalf. That's known as substitute decision making. But that act still requires that whoever has the power to make the ultimate decision takes what the disabled person wants into account. So it's still possible to use supported decision-making techniques to get the disabled person's perspective under the Protection of Personal and Property Rights Act, even if ultimately the law says that someone else has the power to make that decision. But there can, obviously, with the Protection of Personal and Property Rights Act, which is really about substitute decision making and someone else making decisions, there can be a little bit of tension between that and the right to use supported decision making. That's because the Protection of Personal and Property Rights Act is from 1988, and the United Nations Declaration on the Rights of Persons with Disabilities was only written in 2006. So the PPPR Act predates the United Nations saying that everyone has the right to use supported decision making. So even though supported decision making is a human right, it can sometimes be quite difficult to do in practice. So at Aotearoa Disability Law, we often get calls from people saying, hey, I've just been to WINS or to the bank or somewhere else, and they've told me that I as a disabled person need to have a power of attorney in place before the agency will speak to me and my supporters. So it's important to know that if an agency ever does say that to you or someone you support, they are incorrect. Everyone has the right to do supported decision making if they want to. However, sometimes you have to stand up for your right to use supported decision making. So what we're going to do now is we're going to look at some of the elements of supported decision making, and then we'll go through an example to see how this can work in practice, and how disabled people and their supporters can advocate for their right to use supported decision making. So when doing supported decision making, the first thing to work out, and it may seem obvious, but the first thing to work out is what decision do we actually need to make here. It's really important to know exactly what decision it is that you're making, because that's going to determine how much support the disabled person might need. So, for example, if it's a small decision like what to eat for breakfast or what to watch on TV, that might be a decision that you can make on your own without any support. But if it's a bigger or more complicated decision, like deciding to move out of home or deciding to take a certain medication, you might need more support with that. When a decision is big, it can also be helpful to think about whether it can be broken down into several smaller decisions. That then lets the disabled person contribute to making the overall decision by making some or all of those smaller decisions with support. So an example of that might be making the decision that you want to have more control over your own money. That could seem like quite a big and daunting decision, but you could break it down into smaller steps, like what bank do you want to use? What type of account do you want to open? Do you want to have an EFTPOS card or not? Do you want to have someone who can help you manage your money? And if you do, who do you want that support person to be? And so on. So once we've decided what decision actually needs to be made, there are several tools we can use to support people to make decisions. The first thing is that it's really important that the people who are in the role of supporter always start by asking the disabled person what their thoughts are. And as supporters, it's really important that those people listen to the disabled person's point of view respectfully, even if they don't agree with what the disabled person is saying. So there's a concept called the dignity of risk, which refers to the idea that we always accept some risk when we make decisions. We all make bad decisions sometimes, and often we learn the most from those mistakes. And dignity of risk is just about reminding us that disabled people have as much right as anyone else to make bad decisions. So just because a support person doesn't necessarily agree with what the disabled person wants to do, that doesn't mean that the support person gets an automatic veto on that decision. It might be that the support person might want to say, hey, have you thought about this consequence that you maybe haven't considered yet, for example, but it's not an automatic veto. It's also really important that the disabled person gets the opportunity to talk to their circle of support. So your circle of support is the people in your life who you trust to help you make decisions. And you should get to decide who you want to be in your circle of support. So for example, it might be family members, it might be friends, it might be a counsellor or a support worker. And you might want to write down a list of the names and contact details for all of the people in your circle of support, so that when you do have to make decisions, it's really easy to get in touch with those people. And getting the chance to talk to a circle of support is really important because it helps to ensure that it really is the disabled person making the decision. You can probably see that if if a person was always relying on just one supporter to help them make decisions, it might be quite easy for that one person in that support role to take over and end up making the decisions themselves. If the disabled person gets the opportunity to talk to multiple different support people, that just helps make sure that that decision-making power isn't concentrated in one person's hands. It makes it more likely that it is actually the disabled person who gets to make the decision. It's also really important to gather information to help you make the decision. So, for example, if you're deciding whether to take a certain medicine, you might want information about what the medicine is meant to help with, how long you'll need to take it for, what the side effects might be, what you should do if you experience any of those side effects, and how you'll even know if the medicine is working. Obviously, these are things that your doctor should be able to explain to you, or you might be able to find them in the little leaflet that comes in the medication package. It's really important to know that you have the right to receive information in a format that is accessible for you. So, for example, if you need written information provided to you in an easy read or large print format, if you need a sign language interpreter to be present at appointments, those are all things you can ask for. Equally, you know, if you're sitting there and the doctor's explaining the side effects of the medication and they're using big medical jargon that you have no idea what that means, you can even just ask, hey, could you please explain that in a simpler way for me? And finally, arguably the most important element of supported decision making is making sure that the disabled person has enough time to make the decision. So processing all of the information and thinking about what you want to do takes time, and so it's really important that the people in the role of supporter do not rush the disabled person to make the decision. So we're going to take a look now at how this can work in practice. So in this example, we have Jake and his mum Mary. So Jake is the disabled person and Mary is acting in the role of supporter here. So Jake and his mum Mary went to his routine dental appointment at the local hospital. When they met the dentist, she asked Mary questions. She asked Mary to sign a surgery consent form on her son's behalf for his upcoming dental surgery. Mary said that Jake needed to make the decision and sign the form. The dentist insisted that the form required a signature that day so that the surgery could be booked. Mary said that she and Jake needed time to discuss the form and the reasons for signing it. Mary suggested that while the dentist continued with her appointments, Jake and Mary could discuss the form while they were still at the hospital, and then they could come back with a decision. The dentist agreed to this. This gave Jake and Mary time to discuss the surgery and the information on the form. Mary asked Jake if he would like to speak to his stepbrother Rob to talk about it some more. Jake agreed, and Mary used her cell phone to call Rob. Jake had a further discussion with Rob about the surgery and the consequences of having it and not having it. Rob also reminded Jake about the last time he had dental surgery. After talking to Rob, Jake said, "I say yes." When Jake's dental appointment resumed, Mary said that Jake was ready to sign the form. The dentist asked Jake to confirm, and Jake repeated, "I say yes." So a couple of questions to help us think about this scenario here. The first question, and feel free to just shout out what you think, what elements of supported decision making do we see happening in this example? So by elements of supported decision making, I mean basically the things on the last slide. So things like access to information, time, using a circle of support, that sort of thing. Anyone want to shout out some things we see in here?
Time.
Yeah, absolutely. So time is a really important one. They don't get rushed by the dentist into Mary just signing the form. They find a way for Mary to, for Jake to have the time he needs to make that discussion. Good. Anything else? Yeah, absolutely. So Mary is not the only person that Jake talks to about this surgery. He also gets the chance to talk to Rob. The one we maybe don't see there is access to information, but possibly in this example, maybe Jake didn't need that much information to help him make the decision. We know he's had surgery before, and Rob reminded him about that and reminded him what that was like. So maybe Jake felt like that was enough information for him to agree to having the surgery again. Obviously, Mary had a really important role as the supporter in this situation, as an advocate for Jake's right to use supported decision making. She, as we mentioned earlier, she could have, when the dentist said, oh, I really need this form signed today, Mary could have said, oh, okay, fine, just this once, I'll sign it. But she didn't. She found a way for Jake to get the time that he needed to make that decision without making things super complicated for the dentist. But she made sure that Jake's right to use supported decision making was upheld. So supporters in supported decision making do often play a really key role there in making sure that people's right to use supported decision making is upheld. So that's supported decision making, but as we said at the beginning, sometimes some people need more support to make decisions than what supported decision making can provide. So sometimes people need someone else to have the legal power to make decisions for them. And as we mentioned at the beginning, the law that governs these situations in New Zealand is called the Protection of Personal and Property Rights Act, or 1988. We often call that the PPPR or the PPPR Act for short, because protection of personal and property rights is a mouthful. Now, 1988, this law has obviously been around for a while, and basically the context for us writing this law was that back in the 1980s, New Zealand was going through the process of deinstitutionalisation. So we were moving towards supporting disabled people to live in the community rather than having disabled people live in institutions, and so that's why it was felt there was a need for this law. But as I said, it doesn't always fit well with our modern context and our trying to move more towards a focus on supported decision making. As I said at the beginning, United Nations Declaration on the Rights of People with Disabilities is only from 2006, so supported decision making is a more modern context, a more modern concept, and so this means that some parts of this law can seem a little bit outdated, and in fact the Law Commission is currently doing a review of the Protection of Personal and Property Rights Act to see whether any changes need to be made to make it fit 21st century life better. So some of you might have been aware they did some consultation on this in the middle of last year to talk to people about how the law was working and what needed to change. That has now closed. They're working on their report, and when that comes out, we'll see what changes they recommend. Even if they do recommend changes, those would then need to go through Parliament to become law. So even if it is in the process of being reviewed, we've probably still got at least a few years before we see any changes in how the law actually works. So the PPPR Act is what we've got for now. And so the PPPR Act says 4 key things about a person's ability to make decisions. So it starts by presuming that everyone has capacity, and then it says that everyone has the right to make decisions about their lives, unless or until it is proven that the person does not have capacity. And then it also just reaffirms that people should be able to make decisions for themselves whenever possible. And so this is what I was saying at the beginning about there's still space to do supported decision making, even if you do have some sort of enduring power of attorney or order under the PPPR Act in place. Obviously, it's not an on-off thing whether people have the ability to make decisions or not. Sometimes people might be able to make some decisions but not others, and it's really important, and the PPPR Act says that people should be supported to make the decisions that they can make. So obviously, as we can see from this list, a really key concept within this law is capacity. So what is capacity? Well, according to the law, capacity is the ability to make decisions, to understand the consequences of a decision, and to communicate a decision. And capacity is normally determined by a medical assessment. Now, who carries out that assessment is going to depend a bit on the situation. So, for example, how urgent or serious the decision is. So if it's an emergency, the attending doctor might do a quick assessment on capacity. But if it's a more ongoing situation where the person is expected to have an ongoing lack of capacity, that assessment would ideally be done by a doctor or medical practitioner who already knows them well, like their GP, their specialist, or even in some cases a multidisciplinary team. So this flowchart goes through how we use and I know it's a bit small, so sorry about that, goes through how we use the PPPR Act to decide whether someone else needs the power to make decisions for a person. So the first question we start with is the person over 18? That's because until you turn 18, your parents are your legal guardians and are allowed to make decisions for you. So we don't have to be worrying about the PPPR Act at all until someone is getting close to their 18th birthday, or maybe once they've turned 17. Once you're over 18, the next thing to consider is whether you have the capacity to make decisions. If a person is assessed as having the legal capacity to make decisions, they then have the option of setting up an enduring power of attorney. Basically, that's a document that says, if I ever do lose capacity, this is who I would like to make decisions for me. If the person does not have the capacity to make decisions, then someone needs to apply to the family court for the power to make decisions on their behalf. And this is where we come to orders under the PPPR Act. So these essentially are two different pathways to the same outcome. At the end of this flowchart, it's someone else having the legal power to make decisions for a person. The difference is just the pathway we took to get there. So the enduring power of attorney route is for people who do have capacity but are concerned that they might lose capacity at some point in the future and want to nominate a person to make decisions for them at that point. The PPPR Act orders pathway is for people who don't have capacity and don't have an enduring power of attorney in place, and it's reached the point where someone else needs the power to make decisions for them. So we're going to look at the enduring powers of attorney pathway first. So as I said, an enduring power of attorney is a document that you make when you have capacity, and it lets you decide who you want to make decisions for you if you ever do lose capacity. It's obviously a really good idea for all of us to have an enduring power of attorney in place because we never actually know when we might lose capacity. So for example, if you were to walk out of here and have a serious accident and end up in a coma, having an enduring power of attorney in place gives you more legal protection than just relying on someone who is your emergency contact or next of kin to make decisions for you. Having an enduring power of attorney in place means that someone that you have specifically chosen has the power to make decisions for you at that time. So when you create an enduring power of attorney, you are known as the donor, and the person you give the decision-making power to is called the attorney. Now this doesn't mean attorney in the same way as we see it used on American legal shows where attorney and lawyer are interchangeable. In New Zealand, an attorney is just someone who you've given decision-making power to. So it doesn't have to be a lawyer, it can be anyone you trust. Now you can use an enduring power of attorney to authorise someone else to make decisions about your personal care and welfare or about your property. You might want to put the same person into both of those roles. You might want different people in each of those roles. You might decide, actually, I only want an attorney for personal care and welfare. I don't care about having one for property at all. So because you're setting this up when you have the capacity to make decisions, there's quite a lot of scope for you to set it up in the way that works best for you and your whānau. So the attorney for personal care and welfare will only be able to make decisions for you if you lose capacity. And it will be written into the enduring power of attorney document what needs to happen for them to have the power to make decisions for you. So there'll normally be some sort of assessment that needs to happen and forms that need to be signed. So it's not like you sign the enduring power of attorney and immediately your attorney gets to make decisions for you. You've still got to wait to the point where you lose capacity before they can make decisions. Now, the enduring power of attorney for personal care and welfare will generally make decisions about things like where you live, who will look after you, and what medical treatment you will receive. And you get to decide what types of decisions you want to let them make for you. So you might say, I actually only want them to make decisions about my medical care. I don't want them making any decisions about where I live. Or you might say they can make any decisions they want related to my personal care and welfare. Now, with the attorney for property, we've actually got two options. You can decide that, like with the attorney for personal care and welfare, they can only make decisions for you if you ever lose capacity. But with the attorney for property, you can also say, actually, I want this person to be able to make decisions for me while I still have capacity. That's often used, for example, if people are going overseas and need someone in New Zealand who can make decisions related to their property for them. But it's also a really good thing to know about in situations where maybe someone still has the capacity to make decisions about their property, but they would like someone to be able to support them to make those decisions. You can use an enduring power of attorney for property to give that support person a bit more legal power to be a supporter with making decisions. Again, you can decide what powers the attorney for property gets. So you might say, you only can make decisions related to this specific bank account, or you might say you have all the power to make decisions related to all my financial affairs. So you get to decide who you want your attorney to be. There's a couple of things to keep in mind. So legally, the person who you select as your attorney has to be over 20 years old, and they also need to be what the law calls as of sound mind. That basically means they need to have the capacity to make decisions themselves. The next 3 bullet points on this slide are not legal requirements, they're just sensible things to think about. So obviously you probably want to choose someone who you trust to have your best interests at heart. Ideally, you're probably going to want to choose someone who has the skills necessary for managing your affairs. So if you have a friend who you really trust but they're terrible with managing their own money, you might not want to make them your attorney for property. And you need to talk to the person and they need to agree to be your attorney. You can't just say, hey, you're my attorney now. They get a say in the matter. Now, to be legally enforceable, an enduring power of attorney document needs to be signed by you, the donor, and your attorney, and those signatures need to be witnessed by either a lawyer, a legal executive, or an authorised employee of a trustee company. That's just to ensure that the document is all correct and legally enforceable and everyone understands what they're agreeing to. What this does mean, though, is that you need to see a lawyer or a trustee company to help you set up your enduring power of attorney. You can't just write it at home on your computer and print it out and sign it. So at the end of the presentation and on your handouts are some details of organisations that can help you set up an enduring power of attorney. So that's the top branch of the flowchart, but what happens, some people obviously will never have the capacity to set up an enduring power of attorney, and also quite often people do have capacity but they don't set up an enduring power of attorney and then they lose capacity and don't have an enduring power of attorney in place. So this is what the bottom pathway on this flowchart is for. If someone does not have the capacity to make decisions and they do not have an enduring power of attorney in place, then someone needs to apply to the family court for the power to make decisions on that person's behalf. We call these orders under the Protection of Personal and Property Rights Act. So it's free to file these application forms in the court. You don't have to speak to a lawyer to get you to help you fill out these forms if you don't want to. You can just do it yourself. Some people do choose to speak to a lawyer to help them through the application process because it can feel a bit daunting. Just important to know there that if you do speak to a lawyer to help you with PPPR Act applications, that's likely to come at a cost. Sometimes it's possible to get legal aid, but there's a pretty high bar to getting legal aid. The other thing, though, to be aware of is that many of the family courts around the country now really have really good people on staff called family court navigators who are there to help people through all the different family court processes. So if you're looking at filing these applications and you're feeling a bit nervous about it, you want some help but you're not sure whether you can afford a lawyer or whether you want to pay a lawyer to help with that, would be worth ringing up your local family court first and asking to speak with a navigator. They might be able to give you the support you need to get through this process without you having to speak to a lawyer. Once you file the application in the court appoints a lawyer to represent the interests of the person who is thought to lack capacity, so the person whose decision-making power is going to be taken away. It's that lawyer's job to meet with the person and to meet with the person who's applied for the order, and then to advise the judge on whether the person has met the threshold for being able to be given an order under the Protection of Personal and Property Act or not. So basically, whether the person really does lack the capacity to make decisions. And the judge will then make the decision either way. So again, just like with the enduring powers of attorney, we have a split with one pathway for personal care and welfare and then a separate option for property. So with personal care and welfare, the court can decide to just make a specific order, like saying, I order that this person will live in this accommodation, or I order that you will receive this medical treatment. But if the person is expected to have an ongoing lack of capacity, it's more likely that the court will appoint a welfare guardian. And a welfare guardian is a person appointed by the court who can make decisions about someone's personal care and welfare. Now, basically, the bar for the court deciding to appoint a welfare guardian is that they need to be satisfied that the person completely lacks the capacity to make or communicate decisions about their personal care and welfare. And they need to be satisfied that appointing a welfare guardian is the only satisfactory way to ensure that appropriate decisions are made for the person. If the court does decide to appoint you a welfare guardian, they need to try and find out from you who you would like your welfare guardian to be, if they can. Now, the court will initially review the order appointing the welfare guardian after 3 years. After that, they can decide that they're only going to review the order every 5 years, although they can continue to review it more frequently if they want to. The purpose of these reviews are to ensure that the person's rights are being upheld and that the welfare guardian is not making decisions that they're not allowed to make, and also to make sure that no one keeps having a welfare guardian if they regain capacity and no longer need one. However, something that I think maybe got alluded to a little bit this morning as well is that obviously some people, the nature of their disability means that they're always going to need a welfare guardian. That's not going to change. And so in those situations, these reviews can become quite onerous for the person who's in that position of welfare guardian, because they have to keep refiling the forms to the court every 3 to 5 years. A good piece of advice there is when you do that first application for a welfare guardianship order, whether you get a lawyer or someone else to fill that in yourself or whether you do it on your own, keep those forms somewhere safe, because often when it comes time to refile in 3 years or in 5 years time, you can just copy and paste most of the information across, which makes it a little bit less onerous. So sometimes what some people decide to do is they will pay a lawyer to help them prepare the applications the first time around, the first time they get an order, and then they will just keep those completed forms somewhere safe, and then they're confident redoing it for themselves every time they have to refile. Now, a welfare guardian must always protect the person's welfare and best interests, and they need to encourage and support the person to make the decisions that they're able to make and to be a part of their community. So this again is where we come back to the idea that even if you have a welfare guardian, they should still be using supported decision-making tools to help you make the decisions that you can make. They shouldn't just be making every single decision for you. And there are certain decisions that a welfare guardian can't make. So they can't make decisions about you getting married, entering into a civil union, or getting divorced. They can't make decisions about your children being adopted. They can't refuse consent to standard or life-saving medical treatment. This means that a welfare guardian cannot request a do not resuscitate order. They can't consent to you receiving electroconvulsive treatment or brain surgery that is meant to change your behaviour. People are sometimes probably rightly surprised that those things still happen. They are luckily very rare, but they do still occasionally happen, but a welfare guardian can't consent to them. They can't consent to medical experimentation unless it's intended to save your life or prevent serious damage to your health. So for example, if a person had a really rare condition and there was an experimental treatment and nothing else was working, then a welfare guardian could probably consent to that. And they can't consent to assisted dying. So then we have to make separate orders in relation to property. So in terms of property, the court will appoint either a property administrator or a property manager. And the difference here is just how much property you have that you need someone to make decisions about. So as of the 3rd of October last year, if you have less than $25,000 worth of assets, or if you earn less than $40,000 a year, the court will appoint a property administrator. And if you earn more than $40,000 a year, or if you have assets worth more than $25,000, the court will appoint a property manager. Those income thresholds also go up on the 1st of March, the 31st of March each year. So on the 1st of March next year, that income threshold will increase to $41,200. Some of you that have some familiarity with PPPR Act orders might know that those thresholds increased last year for the first time since about 2007, which was really, really good, because basically what had happened was that inflation had meant that those thresholds were basically meaningless. No one came under the threshold for having a property administrator, and everyone was getting a property manager. So it was a good thing that the government stepped in and adjusted those thresholds to make it work a little bit better for everyone. So basically the reason for the difference between the property administrator and the property manager is that because property managers are looking after property or money that is worth more, there are more requirements for them to report back to the court about how they are managing the property, just to make sure that they're managing it responsibly and not doing anything unlawful. And those reports get checked by the public trust. The reason for not requiring everyone to do those reports in the case of property administrators is that they can be a bit onerous. So the feeling is that if the property administrator is not looking after that much money, we maybe don't need quite so high reporting requirements. Now again, like a welfare guardian, the court will initially review the order appointing the property manager or property administrator after 3 years. They can then decide that they only need to review the order appointing a property administrator every 5 years. But they do have to keep looking at the property management order if that's what you have every 3 years. Again, that's just because the property manager is looking after more property, more valuable property. The court wants to make sure that nothing untoward is happening. Now, the order from the court will explain exactly what the property administrator or property manager is allowed to do. So you have to read the order from the court to know exactly what decisions the person in that role is allowed to make. It'll normally be things like managing the person's money and bank accounts, paying their bills, making sure tax returns are filed with IRD if necessary. Obviously, luckily for most of us, IRD does that automatically these days. Renting out a house or flat, and even in some cases managing a business on the person's behalf. And like with a welfare guardian, a property administrator or manager needs to always act in your best interests, and there are certain things they can't do. So they can't be paid for their services unless the court specifically authorises this. Sometimes the court will appoint a professional, like an accountant, in the role of property administrator or property manager. In those cases, the court might say actually they can be paid for their services, but in most cases the person in this role can't be paid. estate. They can get their expenses reimbursed from the person's property though. So if, for example, the property manager decides that they need to pay an accountant to help them manage the person's finances, they can probably get the cost of that accountant reimbursed from the person's property. They can't act in bad faith or without reasonable care. And if they do want to buy or sell property that is worth more than $120,000, they have to get special permission from the family court to do that. So it's really important to know that if you are not happy with the decisions that your welfare guardian, property administrator or property manager is making for you, or if you think that they've made a decision that they don't have the power to make, you always have the right to speak to a lawyer and to ask the court to review the order appointing that person as your welfare guardian, property administrator or property manager. This is absolutely the sort of issue that we help people with at Aotearoa Disability Law. So if you or someone you know wants to speak to a lawyer about these sort of things, feel free to give us a call or help them give us a call. It's also really important that people who are in the role of welfare guardian, property administrator or property manager remember that they have a duty to support and encourage the disabled person to make as many decisions for themselves as they can. Being appointed the welfare guardian or property administrator or property manager doesn't automatically mean you get the power to make every single decision for the person. That is why still continuing to use supported decision-making tools, even if you are a welfare guardian or a property administrator, is a good idea. That not only protects the disabled person's right to make as many decisions for themselves as they can, it also actually protects the person who is in that role of welfare guardian or property administrator or property manager, because it means that they are sticking to making the decisions they're allowed to make. And if the person feels like they're able to have a say over what is happening in their own life, there's less likely to be tension in that relationship as well. So just to finish up, a couple of useful contact details. I've got Aotearoa Disability Law Community Law Centres and the Find a Lawyer page up there, like we talked about before. At Aotearoa Disability Law, we can't make enduring power of attorney documents or help with welfare guardian or property administrator or property manager applications, but we can certainly help if someone has a welfare guardian or a property administrator or manager and wants to challenge that decision or feels uncomfortable or unhappy with the decisions that are being made. However, some community law centres can write enduring power of attorney documents for people. Not 100% sure if that's something that Baywide Community Law Centre does, but worth checking with them if that's something you need. Otherwise, if you are wanting to write an enduring power of attorney and get a lawyer to do it for you, that's where you can go to the Find a Lawyer website. Generally, it's family lawyers that do this sort of work. And again, they should tell you what the cost for that will be before you engage their services. The other option is to go to an organisation like Public Trust. That can often be a cheaper option for getting an enduring power of attorney, because they tend to have sort of standard pre-printed formats that you can just adapt to you, and so then you maybe only need to pay for having someone witness your signatures. So I think that's normally in the order of a couple of $100. The final two things I've got there are two organisations or tools that can help you do supported decision making. So we've got PASAT up there, who are obviously here today, but we know they do great work with supporting people to do supported decision making in the community. And the other thing I've got there is Volition, which is a new app. It was just launched in March this year, and it's basically designed to be a tool that can help people do supported decision making. So at the moment, what it is an app you can download, and it can be a place that you can save your preferences and share them with your circle of support so that everyone knows what sort of things you tend to like. And it also encourages you to update those preferences regularly. So, you know, if you've got stored as a preference that you like having jam on toast for breakfast, you're not stuck doing that forever. If 6 months down the line you decide you'd rather have cereal, you can change that preference as well. So, again, we've got a little bit of time for questions. This presentation's a little bit longer, so there's a little bit less question time, but I am very happy to answer any questions that anyone does have. Yes?
I'm Amy, I'm from
Yes.
Community Law. Sort of,
Yes, absolutely, please jump in.
so we kind of run in multiple ways. We are hoping to expand that in future, but PPPR applications we are now starting to help. Just
Perfect.
as you said, the initial sort of paperwork can sometimes be a bit
Yeah,
daunting, so we are helping with those. Just
awesome. That's fantastic to know. Thank you.
and the other thing I wanted to ask you was, so we're currently paying ourselves for sign language interpreters, things like that. Just wondering if you were aware of any funding available.
I think it really depends on the situation in terms of what funding is available. I think the best place to go is like, for example, if I was doing an education session, we would pay for the interpreters at Aotearoa Disability Law. I'm not sure what happens when we have clients who need sign language interpreting, but I think generally the interpreting organisations should know about that, so worth asking them. Otherwise, maybe send me an email and I can ask our admin team how we pay for them, because I don't actually know off the top of my head, sorry. But yeah, flick me an email and I can ask. Any other questions?
What percentage of the population, whether they're disability or not, actually go through all this and power of attorney and PPPR, etc.?
I don't know, is the answer to that question. I mean, in theory, everyone should write an enduring power of attorney, right? If you can, because we will all probably lose capacity at some point as we get older. It's a really important part of future planning. I certainly don't think everyone does have one, but ideally everyone should. In theory, the PPPR Act, the court order process, should only be used for those people who have really the highest level of need. If you remember, the threshold for the court actually appointing a welfare guardian is quite high. They have to be completely satisfied that it's the only way for appropriate decisions to be made for the person. But yeah, I don't know the exact numbers, sorry.
Yeah, with the population with dementia and things like that, I can understand having this.
Yeah. But again, ideally with something like dementia that tends to come on later in life, what we should really be trying to encourage everyone to do is to set up an enduring power of attorney so that they don't end up having to go through that court process, which is often really burdensome for families, but also means that you have less say in who that person is that gets to make decisions for you. That's okay. Cool, well, oh yes.
All right. If you have a power of, just a basic power of attorney that was set up before it became an enduring power of attorney,
Yeah.
has it been revoked? Is that still going to be legit?
I don't know the answer to that. I would assume it would depend. Presumably you'd probably have to read the document and see what it actually... Right. Yeah, that's probably something that maybe you would, if it's not clear from the document, you probably need to take that to a lawyer to get them to help you figure that one out, sorry. Yeah, normally with an enduring power of attorney, it will have, thresholds for when it comes into force and stuff. So if the power of attorney doesn't, yeah, you probably need to talk to a lawyer. Just before, I know Peter's standing behind me, just before we finish off, we get funding from Spectrum Foundation to run these sessions, so I would really appreciate if before you leave, if you could just fill in one of these feedback forms and maybe just leave it on the table up here for me to take away. That just lets us know, tell Spectrum that hopefully this was useful and they should continue funding it. Obviously very happy to answer any other questions people have, but I'll just pass these around now.
Thank you very much, Rachel, again.
thank you.
Thought-provoking. From personal experience, please do look into getting an enduring power of attorney and setting up some difficult discussions with the loved ones in your families and amongst yourselves. No one thinks we're going to be incapacitated at any time, but it can, as you said, happen at any time. So it is definitely worth a discussion to have with your family, so you can share what you want and what they want back from you. It's very difficult to have those conversations, but well worth it. If we could just show our appreciation to Rachel in the usual manner for her contribution. I'd like to ask Milton to just close the meeting and just wish you all a safe journey back to your whānau. Thank you.
E te atua kua kamutu tā mātou mahi mō tēnei wā. Manaki tia mai mātou katoa, o mātou hoa, o mātou whānau, ai o ki te aorangi, tuturu whakamaua, tīna, huie, tai,
Tai hie.